Buying a home by yourself can be a lot. Buying a home with a realtor isn't. Paperwork, inspections, appraisals, deadlines, showings, market research. What you reading? Viewings, understanding legal documents, negotiating offers, coordinating inspections, securing financing, handling close. Well, you get the idea. A realtor can expertly handle the details, so you don't have to.
Good morning, everyone, and thank you for joining us today. You just saw the consumer campaign that the WRA launched several weeks ago, and we'll be playing on a variety of different channels, including social media, uh, radio ads, and also billboards. It's an effort to counteract some of the negative national news media stories about real estate commissions and the value that realtors provide in the transaction. So look for that on social media. Please share it. Give us your feedback. You'll see a number of these ads over the next 12 to 24 months. So if you have questions, please put them in the chat. The presenters will be able to see the questions. We'll respond if we have time. And for any unanswered questions, please call or submit them on to the WRA hotline. We want to just to kind of highlight the settlement agreement, a few important dates. We are exactly 101 days since NAR entered into the settlement agreement on March 15th. It seems like years, but it's only been just over 100 days. And the legal team has done an outstanding job trying to get their arms around these changes and what they mean for Wisconsin. And this has been kind of a moving target with different interpretations coming out over the various weeks and months. So we've done a very good job of trying to decipher these changes and what it means for Wisconsin. Another important date that I just wanted to mention was the June 18th date. That was the date for MLSs, both realtor-owned and non-realtor-owned MLSs, to opt into the settlement agreement. And it was also the date for brokerages who were left out of the settlement agreement to opt into the agreement. The one, though, that we're going to be talking about, the big date, is August 17th. That is the date that the practice changes will go into effect. There's been some discussion about whether the deadline for those practice changes will be September 16th or August 17th. August 17th is the most conservative date and the date that we're all comfortable with to ensure that you receive the protection necessary from the lawsuits. Remember what this is. This is not a federal law change. These are not state law changes. These are terms of a settlement agreement that, if implemented, will provide you with liability protection from these seller-based class action lawsuits. That's why we're trying to encourage the earliest possible implementation date to ensure that you have the protection necessary from these potential lawsuits. The other date to remember is the November 26th date. That is the date that the court is scheduled to finalize the agreement. Before going into the practice changes, we want to just update you on a couple of other things that we are watching that could have an impact at some point in the future on practice changes. The first is the U.S. Department of Justice and both their investigation of NAR and also what's called a statement of interest. A statement of interest is essentially a brief that is filed by the Department of Justice, and they can do it with any federal court case. And it is a brief that explains maybe how the DOJ feels about a potential lawsuit or potential settlement agreement. And the DOJ has been very active in filing these statements of interest in cases all across the country. They've done it in a number of real estate cases, but also non-realtor cases. The most recent example of that was a Massachusetts case, often referred to as the No Select case, where the DOJ filed a statement of interest regarding the offers of compensation of MLS. And in that statement of interest, the DOJ provided some alternative offers of compensation models that they would prefer. And namely, they would like to eliminate all sellers' or offers of compensation. And they came up with a couple of different models. One is just to ban those offers completely, and the second is requiring the buyer to have to make the request to the seller. Again, remember, this is only the DOJ's desire. It is not federal law. It has no legal authority, and it is up for the court to take into consideration how much, if any, weight to give to these statements of interest. They could still file one in the NAR settlement agreement. And we don't think it's likely, but it could happen. And the reason why we don't think it's likely is that the NAR settlement agreement goes much further than the NOSELIC case and actually incorporates practice changes that were not in the NOSELIC case. And the DOJ did not file a statement of interest in the settlements with any of the private real estate companies. So we think that they're not inclined to file one in this case. And even if they do, the court is not required to follow it. It's only voluntary. Anybody can file a statement of interest or a friend of the court brief. And the court has given us some indication by approving the preliminary settlement that they are fine with the proposed settlement changes, and they think that they are fair and reasonable. So unless the court does an about face, we think it's likely, or at least a good chance, that they would not follow any DOJ statement of interest if they do file one. The other thing to watch, and we have not talked about this much, is the series of buyer class action lawsuits that have been filed around the country. There have been 4 filed to date. 2 are probably more advanced or are further along in the process than the other 2. And the first one is considered Batten 1, or called Batten 1 case, out of the Northern District of Illinois. And in February, the court dismissed the federal claims in that case, but allowed the state claims to continue. And this has a very prolonged schedule in terms of when the litigation is set to occur. As you can see, the trial is not set to even begin until 2027. So this is somewhere down the line, and it is only based upon state claims, and Wisconsin was not one of the states named in those lawsuits. So we have no reason to believe that Wisconsin would be implicated by the Batten 1 suit. And the other case is called the Batten 2 suit, also out of the Northern District of Illinois. And there were some recent filings in May of that case. And that case involves 28 state antitrust laws and 25 state consumer protection laws. Again, Wisconsin was not implicated in that case, and we don't think that it could be applicable to Wisconsin, but it's just something to watch in the event that Wisconsin gets added, or in the event a copycat buyer class action lawsuits gets filed in Wisconsin. You'll at least be aware that they are still pending, and then that issue is yet to be resolved. So just wanted to update you both on the DOJ and buyer class action issues. I'm going to now turn it over to Corey to talk about the practice changes.
Well, hi, everyone. We are going to cover quite a bit of information in a short amount of time. We will obviously have a great deal of articles, talking points, website information for you. But Jennifer Lindsley and I will be covering a couple of the things relating to the practice changes. So as Tom mentioned, on August 17th, you're going to have 2 practice changes that NAR has committed to making. And so we just want to cover these briefly with you so that you can have a better grasp on it. And again, we will continue to communicate with you. So the first change, again, effective August 17th of this year, is the one that's relating to offers of compensation. So as of this date, MLSs will no longer be able to include offers of compensation. So that means that you'll no longer have a field as a listing broker to communicate that through the MLS. So we get a number of questions relating to this. As far as when is this change going to be implemented by the MLSs, we've heard that most Wisconsin MLSs will be making this change sometime in mid-August. Of course, each MLS gets to make their own decision, so contact your local MLS if you have specific questions. A number of other questions we get: can we include this information on showing platforms? Can we include this in our MLS associated documents? Can we create some sort of realtor-owned or MLS-created or owned platform that allows this type of disclosure? That answer to all of those are no. So one of the things I received in the chat here is, are we able to communicate in the public remarks in the MLS about offers of compensation? We've been told that that is a no. And again, your MLS will create rules and parameters for you and communicate to you. But the idea is that they want transparency in this conversation. And so you'll no longer be able to communicate this through the MLS. So that is part of the first change for you. But there's a couple of things that the settlement agreement specifically allows, and so we just want to kind of relay this information to you as well. So per the settlement agreement, it does clearly say that listing firms may display offers of compensation on their listings on their own website. So if it's my listing, I'm able on my website to communicate to you my offer of compensation. And then of course, we're going to figure out how we're going to actually agree to that. But that is something the settlement specifically allows for. In addition, the settlement says that seller concessions may also be offered on the MLS if your MLS rules allow. Again, each MLS gets to create their own rules. But it says in the settlement agreement, if they're going to offer seller concessions on the MLS, they cannot be conditioned on the payment to the buyer's firm. So my seller says that they would be willing to have a seller concession just like they could today. They may say that they're willing to have it up to a certain dollar amount, a certain percentage, whatever it is. And our listing contract, and Jennifer is going to talk to you about some of the WB form changes in just a minute. The listing contract can indicate what the concession is and how it's going to be utilized, which could include the payment to the buyer's firm. Once you place that communication out in the MLS, however, you can say that there is, if your MLS permits, you're able to communicate that there's a concession, but you cannot condition it on the payment to the buyer's firm. But then when we get back to the contract between the parties, you may indicate that there's concessions and you may provide what those concessions are being used for, which again may include the buyer's firm being paid. So in the two listing contract and offer to purchase, you can talk about it, you can say what it's about, but not in the MLS. You can only communicate that there is a concession. And I know we have quite a few kind of conversations coming up through the chat, so we'll try to make sure we're answering those as we get through all the discussions here, but we are tracking those. And so the settlement agreement does also prohibit, however, blanket compensation agreements, or what we often refer to as policy letters within our state. The idea here is that any offers of compensation require the seller's approval, and so they must first be in writing, these approvals, and they must be provided in advance of any payment or agreement to pay the cooperating firm, and they have to specify the amount or the rate of such payment. So Jennifer's going to talk to you about what that means in the listing contracts. But if you had some sort of standing compensation agreement, whether that was a policy letter or some other document, as of August 17th, those would not necessarily be enforceable or permitted because they would be against what the settlement agreement allows. So again, communicating offers of compensation from the listing firm to the cooperating firm may vary, and there should be an evidence of an agreement as to what you're agreeing to as far as the amount and the standard of performance. And so we are revising our compensation agreement. We currently do have one within our zip form and forms library. We're going to update this a bit to create a standard of performance and kind of address some of the settlement agreement discussions. And again, we just want to remind you that this is between the firms and not the individual agents. And so again, we'll be creating a lot more conversation and education for you about these discussions, but that is the first practice change that's being implemented. The second practice change has to do with buyer written agreements. So the settlement agreement says that MLS participants working with buyers must enter into written agreements with buyers before touring the home. And so we know that these written agreements have specific things that the settlement agreement says that you have to include in them. So here's kind of a bit of a tricky thing for us. So one of the things that we've been having everybody say, so does that mean that right away I have to have buyer agency with the buyer? You don't have to, you can, but the objective here is to make sure there's some sort of written agreement with the buyer before you tour a home with them. So when we start looking at NAR's FAQs, which have been quite helpful in understanding and interpreting what the settlement agreement is, there's a couple of things that we just want to kind of lay out for you. Per NAR's FAQs, if you're the listing agent or a subagent, you don't have to have a written agreement before touring the home. So the most common question we get is, if I'm the listing agent and I'm having an open house, do I have to have a written agreement with the buyer before they enter the open house? No. If you're the listing agent, you do not. If you're a subagent, according to NAR's FAQs, you do not. If you're a buyer's agent, you must have a written agreement before you tour the home. This is nice for us. We already have buyer agency agreements. We have the WB forms that you're required to use. So this isn't a surprise for you because you're wanting to have a buyer-client relationship. You already know the steps you have to take. Here's the thing that we're going to talk a little bit more deeply about, and this is what we refer to as pre-agency in our state, which is when you're not the listing agent and you're not a sub-agent and you're not the buyer's agent. According to the NAR's FAQs, we will have to now memorialize, we will have to document this pre-agency phase in the state of Wisconsin because we must, in pre-agency, according to the settlement, we must have a written agreement with the buyer before we tour the home. So let's go way back to the day of whether it was 15 minutes ago when you got your license or 30 years ago. Let's talk about agency. So there are 3 different ways that a buyer can have a relationship with you as a real estate agent in this state. And it all depends on the level of service that you're going to offer, what your kind of position is. So we have pre-agency, you have customer, and you have client. So as I mentioned earlier, pre-agency means that you're neither a client or a customer, that buyer's neither your client nor customer. I always think of it as you're just getting to know each other. You're able to show them properties, but you're not having to commit to this conversation of client or customer. You don't have to participate in pre-agency. You can skip right over and give them this disclosure to customer form, or you can enter into buyer agency with them. But that exists today under Wisconsin's law. Couple of things in pre-agency. If you're participating in pre-agency, as a reminder, and when we get into this agreement, you cannot negotiate. So most common activity there is writing an offer. So in pre-agency, you kind of get to have this discussion, you get to show them properties, but at some point you have to go beyond pre-agency to participate in the transaction, and you have to have a client or customer relationship. So the next one is the customer relationship, which is meaning that you're either the cooperating firm, you're not a listing firm, so you'd be the subagent. You're the listing, you're working with the listing firm, so you're the agent of the seller, or in that circumstance where you have buyer agency and you're helping the buyer purchase a for sale by owner, a FSBO, you're providing them this disclosure to customer form. So the agent owes the duties to all parties in loyalty to the seller in this circumstance, in the most common circumstance when you're working with the buyer as a customer. And you have this required state written disclosure document, and WRA has one of these forms created, or your firm has created one for you. Then you have the other relationship, which is the client relationship, which is when you're wanting to provide those client level services. So you're going to have the buyer agency agreement, and that's either your WB 36, WB 38, or your tenant rep, which is the WB 39. And you owe duties to all parties and the client in this discussion. So I mentioned to you that per the settlement agreement, we are now going to have to document your pre-agency relationship if you're choosing to participate in pre-agency with a buyer. So WRA has created what we're referring to as our pre-agency showing agreement. It's, again, created to meet the settlement terms. It's going to have those required documents in there. It's also going to be this one that you're going to provide if you're participating in pre-agency. I mentioned you can skip right over pre-agency and you can go to a client or customer relationship. Again, you can't negotiate, which is what this agreement is going to emphasize to the consumer. And again, the form educates them about what pre-agency is, what the agents can or cannot do in pre-agency. It emphasizes that it's not an agency agreement. It incorporates the settlement language. And we are going to provide you additional information and separate education about this pre-agency form. And we will provide you what it looks like and what it does in a separate discussion, because again, we could spend quite a bit of time just on this discussion. Another thing is if you're participating as this customer relationship, we are revising our broker or our disclosure to customer form to ensure that the buyer receives the spirit of the settlement when they're not presented a pre-agency showing agreement or buyer agency agreement. Again, this is just to make sure that we're documenting this discussion in an effort to try to get that transparency. And so that's why WRA is going to revise our disclosure to customer form, even though the settlement agreement doesn't say that you have to have this because you are a subagent or an agent of the listing firm, but we're just going to do this as an additional step. So again, it's a conservative approach. It maintains the current disclosure language, and it includes certain settlement agreement language just to provide that clarification. And again, we will provide you separate information and education about this form and the way it can be utilized. The last thing I just wanted to cover with you are these other WRA form changes. So we're looking at creating one or more disclosure forms where you can incorporate into your agency agreements that you're not that are not the new ones that Jennifer's going to cover for you. Potentially some amendment language in certain circumstances that may need to be utilized. I mentioned to you that we're revising our firm-to-firm compensation agreements, and then we're going to make sure that all of these are available to you before the mandatory use date and well before the mandatory use date of August 15th, which Jennifer is going to cover for you in just a minute. So I'm going to hand it off to Jennifer so she can talk to you about the state approved forms.
Good morning, everybody. I will be covering the form changes. Just a couple things. We're getting some questions in the chat, a lot of them in the realm of pre-agency and sub-agency and which contracts do you need. So let me just go over the form changes quickly, and then we will jump into those questions and start addressing those. We had a number of questions too about whether this presentation is going to be recorded. It is being recorded and will be made available to you later on our antitrust web page. And one of the questions asked how quickly will it be available? And I guess I don't know the firm answer to that, but I will try to find out before we are done here. But for those of you that were taking notes, you'll be able to go back and rewatch this. So to the forms changes, the Forms Council was very busy. They revised all of the WB1 listing or all the WB listing contracts. So residential, commercial, vacant land, all of them, all the buyer agency and tenant representation agreements, and all of the offers to purchase, and the option as well. We are looking at a July 1, 2024 optional use date, which is right around the corner, and an August 15th mandatory use date, so that those forms are in place before that August 17th deadline for the practice changes. And I'm going to talk more about what the specific changes are and when we hope to have these forms available. Where can you find a summary? We have a forms update resource page on our website that right now includes a summary of what the changes to the forms are, just high level, what's going on with the listing contract offers and then buyer agency. Where can you find the new forms as of July 1, 2024? The DSPS has said that they will be available on their website as of July 1 for that optional use date. We will have them in our WRA PDF forms library. We will have them in zip form. I don't want to promise it will be by July 1st because there's a volume of forms that they are looking to get updated. They're hoping to have it as soon as possible, but be on the lookout for that. We will make them available. And reminder, our WRA forms library is included as a member benefit to you. So even if there is a lag in getting them up on zip form, which hopefully will not be too long, you will have access to PDFs of these forms as of July 1 of 2024. The listing contract changes. The good news is that the changes to the listing contract were consistent across all listing contracts. So it's not like you'll be looking at the residential and having to be searching in the vacant land to find some other change. These were all uniform across all the listing contracts. One quick revision was in the marketing section on the first page. You've always been allowed to advertise incentives and special financing offered by the seller that they indicated in that marketing section. This was just slightly revised to include the word concessions so that if a seller is offering concessions, you are now allowed to advertise those. And it clarifies that if the seller is offering concessions, that's in addition to compensation to others. And then it refers to the appropriate section of the listing contract. There's language that was added too in that note that concessions offered in the multiple listing service cannot be conditioned on the retention or payment to a cooperating firm, buyer's firm, or other buyer's representative. That's just compliance with the settlement agreement, adding that language just to make sure that our listing contracts are in compliance with the requirements of the NAR proposed settlement agreement. The compensation to others section too, this was also revised. And it says the firm is disclosed and the seller approves offers of compensation. Our listing contracts have always had this permissive language in there about offers of compensation. This is just a slight modification of that because the language of the proposed settlement says that before a firm can make an offer of compensation or agree to pay a cooperating firm, it first has to be disclosed to the seller and the seller has to approve that. So that's why this language was added there, to make sure we're getting that disclosure made to the seller and getting the seller's approval of any offer of compensation. The language at the bottom of that, there's no standard market commission rate. That's been there. Commissions and types of service may vary by firm. The new language is commissions are not set by law and fully negotiable, which has always been true. That's always been the case. It's just amping that up for a little consumer transparency in those listing contracts. And that's it. That's all the changes to the listing contracts. Buyer agency and tenant rep. Functionally, not huge changes here. There were some additional notes to clarify for consumers how this relationship works. The first note is a firm may not represent that the firm's services are free or available at no cost to their client unless they will receive no financial compensation. That's been in the Code of Ethics since 2022. And what we just want to make sure that a firm is not saying, hey, buyer, let's do buyer agency. My services are free because I'm going to try to negotiate some offer of compensation from the listing firm. Well, that's not free. It's just somebody else is paying that bill. So a firm cannot represent that their services are free unless they're not getting any money from anybody involved in that transaction. The second note is the specific amount or rate of compensation must be objectively ascertainable. Give an example, specific percentage of the purchase price, flat dollar amount, hourly rate, and it cannot be open-ended, such as whatever the seller is offering the buyer's firm. That more is just an educational tool for the parties. So in the past, occasionally we would hear about firms writing to their buyer agency agreement that the compensation is whatever the listing firm is offering. That's not going to be allowed, or whatever is offered on the MLS or whatever the seller's offering. That's not objectively ascertainable. The firm's commission must be stated as an amount that is clear and the buyer understands it. So if that's a practice that you've seen where people just say whatever the seller's offering or whatever's offered in the MLS, no more. It wasn't a good practice to begin with. We definitely don't want to do it going forward. Further, that the third point was language added again about commissions and types of service may vary based on the firm that you hire, and they're not set by law and they're fully negotiable. The last note that was added is the firm cannot receive compensation for brokerage services from any source that exceeds the amount or rate agreed to in this agreement. Just clarification that if the buyer's agreement says their buyer's going to pay X and there's a listing firm that's offering Y and Y is more than X, the buyer's firm cannot receive more than what was agreed to in that buyer agency agreement. I don't know that that's been a widespread practice out there, but it's just further clarification so the consumer understands what it is that they are going to owe to their firm. This change to the offer to purchase, this is an optional checkbox that's being added to all of the offers to purchase that a buyer can use to ask the seller to pay the buyer's firm's fee. This has always been allowed. This is not anything new. There's always been a way to do this by including it in the offer, in the additional provisions, or an addendum where the buyer's just asking the seller to pay the buyer's firm's fee. This is just, the thought was, well, let's just add it into the offers as a checkbox so that parties can have that discussion whether they want to ask the seller to pay the buyer's firm's fee. And they drafted this pretty nicely, the way that it's laid out. It says seller agrees to pay the buyer's firm the amount of. And rather than specifying it as a dollar amount or a percentage of the purchase price, they gave the buyer some choices or suggestions or ideas about how they want to negotiate this. It's going to be paid towards the buyer's firm's fee. And then there's language just saying that it doesn't create an agency relationship with the seller. So that's going to be new in the offers. So what are we going to do next? We'll have email updates, magazine articles, talking points, FAQs are getting updated. We're going to have, like Corey was mentioning, little educational pieces on some of these new forms that we are taking a look at, more presentations coming for you. Resources, the antitrust resource page, that's where this video will be available at some point soon, so you can rewatch it if you haven't already, or if you've got agents in your firm that were not able to attend today, you can send them to that resource page. And then the National Association of Realtors resources, Facts.Realtor, they've been really good about keeping that updated if they have new information that they want to share with their members. Competition.Realtor, and then the NAR FAQs are on Facts.Realtor. I think the last time those were updated was May 30th, but they've now started including dates when they update a question so you can see what's new in their interpretation. If you have questions that we don't get to, which we're going to have time for questions today, if there's something that we didn't cover or your question didn't get answered, feel free to reach out to the legal hotline, and we're all aware that we will be able to answer questions through that tool. And if you have not already taken course 6, which is the case law course, and you would like an hour of CE credit for attending this session today, you can go out into your MyWRA and there will be a link for you to take the exam. It's 5 questions and get an hour of continuing education credit for attending this today.
So that brings us to the questions portion, Jennifer, of our discussion today. And Tom, I've been furiously trying to write down some of the questions, so I'm going to ask some of them. So Jennifer, you had mentioned about the buyer agency agreement. Can you place a range in the buyer agency agreement for compensation?
I'm going to tell you my interpretation of this. This is one of NAR's FAQs, and they didn't directly say yes or no whether a range was going to be okay. To hedge on the side of safety, I would say no. If they would have come out and said, yes, you can have it as a range, I would feel more comfortable saying yes to that, but they didn't say yes or no. They just said compensation must be objectively ascertainable. It cannot be open-ended. The buyer's firm can't receive more than what was agreed to in the buyer's firm agreement, just kind of reiterating what our standards are. So I might be a little conservative in my interpretation of that, but I don't think the range is preferable. We have had discussions where the firm can say, we will charge X% or X dollar amount, whichever is greater. I'm pretty comfortable saying that that's okay, because that's objectively ascertainable, that there's a max that the buyer is going to pay, but personally speaking, the range makes me a little bit nervous.
And then Jennifer, you mentioned the fact that the settlement language says that it cannot exceed, right? You can't receive more than what the buyer has agreed to. Can you amend your buyer agency agreement if you're able to get more compensation from the cooperating firm as a cooperating firm?
100%. So if your buyer agency agreement is sitting at X, the listing firm's offering Y, and that's more than X, you can, with your buyer, ask to amend the buyer agency agreement. Just a quick reminder, though, that agents don't have the authority to change the commission amount, shorten the term, or expire an agency agreement, listing contract, or buyer agency agreement without the supervising broker's permission. So supervising brokers are going to want to have a discussion with their firm about how do you want to handle that. Do you give written authorization to your agents that they have your permission to amend the commission amount up? But if they're going to amend it down, that has to be a case-by-case basis. I'm not saying that there's one right way to do that. That's something that firms will want to consider as guidance to their agents, how they want to handle it. But legally speaking, yes, you can amend up.
And then I see there's been a few different questions in the chat about various MLSs and how they're going to be applying the rules. Please reach out to your specific MLS. We don't want to commit some sort of policy on their behalf. So you'll need to speak to them about whether, for example, they're going to be offering seller concessions or not. And then I do want to reiterate in pre-agency, there's been, again, some conversation there. In pre-agency, our agreement will provide the opportunity to charge some sort of fee if you would like. You're not obligated to, but we'll provide you this opportunity. But please understand that's just for showing properties. In order to write offers, you must become a customer or client relationship. So you can't write offers under pre-agency. And that, again, is reasons why we'll be specifically having individual courses and education about pre-agency, showing agreements, and just the disclosure to customer language. And then Jennifer, there's been a question here about the application to the commercial contracts. Could you explain why those changes were made, please?
Yes, before I do the commercial, there's a question that came in that's kind of piggybacking off the pre-agency agreement. This notion that if you give a buyer this written agreement to show properties and then things are going well and the buyer says, actually, I do want to do buyer agency with you before I draft the offer, you can absolutely at that point convert over to buyer agency. At some point, even if you're in pre-agency with the buyer, at some point, the buyer's going to have to make a decision about whether they're going to be a customer or a client. And that typically is triggered by negotiations, which the easiest example of that is drafting an offer. So even if you're hanging out in pre-agency with the buyer and they start talking offer, at that point, you're going to have to say, wait a minute, buyer, we need to have a further discussion about how this is going to go. Do you want to be my customer, in which case X, Y, and Z are true? Or do you want to be my client, in which case A, B, and C are true? Pick your route, okay, disclosure to customer form or buyer agency at that point. So this pre-agency stage is not a forever stage. It's just the pre part before we decide what is the agency. Commercial, the applicability to this with commercial, as I mentioned, the listing contracts were all revised, including the commercial, and the buyer agency, including the commercial. Those were all revised to include these practice changes. NAR has made it pretty clear that the terms of their settlement agreement were really directed at residential properties. And in fact, this whole pre-agency agreement, they specifically said that's before touring a home. In terms of the applicability of these practice changes to commercial, I kind of feel like I have a range of how I think it applies. Like this, again, might be me being a conservative interpretation, but I got this question asked about vacant land. If it's just 40 acres of soybean, I'm not worried about you having a touring agreement. If it's a plot that somebody's looking to build a house on, then I think the safest thing is to go ahead and have that pre-agency agreement or make the decision. If it's commercial, but it's mixed use and there's some dwelling units in it, then again, I think we're probably back in the world of being safe and complying with all of these practice changes. If people are realtor members, that's why we added this into all of the existing listing contracts and buyer agency agreements. It's just to be safe and make sure everyone's complying with the spirit of the proposed settlement agreements.
And then just again, and this is no surprise that you're going to have several questions about this pre-agency agreement. One of the questions is, if it's a WRA form, how are we able to use it? You are required to use WB forms as a Wisconsin real estate licensee. However, when one is not available, you're able to use forms drafted by attorneys in one capacity, which is why you get to utilize WRA attorney forms or WRA forms that are created by attorneys. So this form is created and drafted by WRA legal counsel. And that's how you'll be able to utilize the pre-agency agreement, I should say. In addition, I want to say that firms are also able to create their own. So it may be possible that your company will decide that they'd like to create their own pre-agency showing agreement to meet the settlement terms, but also creating it the way that your company would like it to be drafted. And then I had a question about WRA's pre-agency agreement, whether that is for one individual property or many. It's up to you how you want to draft it. So again, that is one thing that isn't defined in that. A couple of other things that are not defined. I see that we've got questions about what does it mean to have seller concessions. That is not defined in NAR's or in the settlement agreement. So again, you try to do the best you can as to the settlement agreement language, but it's not defined. So we'll hopefully find more out as we move forward. And then Jennifer, the question about, I have a current listing or buyer agency agreement today. What do I do as of August 17th when these changes are implemented?
Great question. What we are working on right now is a one-page disclosure that you can use that will incorporate the settlement language so that your contract going forward will be compliant with the National Association proposed settlement agreement. For listing contracts, I'm confident that that disclosure that we're going to have signed by the seller is going to be sufficient to incorporate the proposed terms of the settlement agreement into your listing contract. The one instance I see where buyer agency agreements will need to be amended is if they're existing buyer agency agreements and the compensation is stated as whatever's offered in the MLS. Well, obviously that's going away, or whatever the seller's offering or whatever the listing firm is offering. As of August 17th, a term like that will be in violation of the settlement agreement terms. So if you have buyer agency agreements or your agents have buyer agency agreements where the compensation is open-ended and not objectively ascertainable, you'll want to amend those. And we do have a WB 47 amendment to buyer agency tenant rep agreement. It's a one-page form, in and out. It will not be a difficult challenge. And while I'm here, I saw another question that came in that was asking about the line-by-line trainings getting updated. We are in the process right now of revising all of our education to comply with terms of the settlement agreement, including your continuing education. For those of you that mentor new licensees, the pre-licensing sales and broker is all being modified to comply with the terms of the settlement and also to incorporate all the forms. So not only will line by line be updated, I can give you my word that our CE and pre-license will be ready to go by August 17th, if not sooner. I'm hoping we can get there with the line by line, but because of the volume of forms that changed that might be slightly delayed. We'll obviously start with the big ones, the listing contract, buyer agency, residential offer to purchase, and then work our way through in terms of order of use. And before anyone panics, if you've already taken your CE, you don't need to retake it. We're just amending this so going forward, people are getting the accurate information up to that point. So no one's going to make you retake your continuing education. If you're done, you're done. But if you're going to do it going forward, it's going to have the most up-to-date current information.
And so I'm, again, just going to keep going through some of the questions. One of the questions was, how do you complete the compensation language in the listing contracts, buyer agency agreements? It was a very good conversation at the Department of Safety and Professional Services Forms Council with the Real Estate Examining Board recommendations. They didn't want to make any substantial changes to the forms at this time. They wanted to meet the intent of the settlement agreement. So it is going to be up to each company and firm how they decide to complete those blank lines. And so that is something that you will work with your firm and its policy relating to that. I'm going to keep going while Jennifer has an opportunity to catch up in the chat. As far as procuring cause, this has been a common conversation that we've received. So you are correct. There is no longer an MLS offer of compensation. However, as a realtor, you still have a duty to arbitrate. And so in the event that you have an agreement for compensation and you're wanting to challenge it, you will go through that same process that you did if you were challenging an MLS offer of compensation. The kicker here is, however, your individual compensation agreement that you'll be entering into transaction by transaction will need a standard of performance, if you will, in its contract. So the WRA's compensation agreement that we'll be releasing in the very near future, the standard of performance will be procuring cause because it's what everybody knows. But there could be different standards of performance. So it's not that procuring cause goes away. It's just where it may now be included. It just won't be in the MLS because there's no longer an MLS offer of compensation. I also had a question in the chat that talked about the how can we be a subagent if there's no longer an MLS offer of compensation? So the subagency exists by statute, which is created by state law, and that's not created by the MLS. And so the MLS is there to facilitate cooperation and at the time compensation. When the compensation ceases to exist, subagency still continues. It's just how you're going to receive compensation. And so that's why one of the conversations just had to be, how do we discuss with each other what our compensation with each other is going to be? And that's where we think we'll see some creative solutions. I am going to use this opportunity, however, to say, don't go to the internet or social platforms for some of your ideas. Please turn to your legal team. Use us as a resource because we've been hearing about some maybe questionable or not successful plans that don't meet the intent of the settlement agreement that we're hearing from other states, not necessarily in our own. But we just want to make sure that if you hear it on the internet, maybe question it, call the legal hotline just to see if that plan is a good plan or a bad plan. And again, what's amazing about the Realtor community is you are ever evolving in technology and business models and creativity, but we have to make sure that we're not being so creative that we somehow have created harm for yourself. And so please call the legal hotline if you have questions about, hey, is this a good idea? Is this not a good idea? And we'll do our best to continue to update different materials. We will be releasing an FAQ about practice questions, hopefully sometime tomorrow, if not later today, where we'll be answering a lot of these questions. We wanted to be able to see what exactly you were asking so that we could find some common thread so that this was a good resource tool for you. So Jennifer, did you have a chance to catch up?
I did have and please forgive me if you mentioned this. I might have been reading the questions and didn't hear you, but did we talk about open houses?
I mentioned it really quickly in my discussion, so feel free to capitalize.
This touring agreement, it's for showing a property, and NAR has said specifically this is not for open houses. It's for you as an agent taking a buyer to a property for their own special tour or showing of the property. They've indicated that it's not needed for open houses, but could you certainly start the discussion with parties at an open house about if they want to work with you, buyer agency, what does that look like, unless they already have a buyer's agent, in which case we're gonna not touch that. But that's just a clarification about the open house situation. And then I had another one. Let's say that you're an agent and you're working with a buyer and the buyer doesn't want to pay you, so they don't sign buyer agency, and the seller or the listing firm is not offering compensation. What do? You have to reevaluate whether you want to work with that buyer, because if the buyer doesn't want to pay you and the seller doesn't want to pay you, you don't want to work for free, nor are you ever required to work for free. So you might want to have a conversation with that buyer about how useful you will be in that transaction and negotiate with your supervising broker's permission a fee that is agreeable between you and that buyer. Or you could suggest, you could do buyer agency and then have a further discussion with the buyer about that you could use the offer to at least ask the seller to pay the buyer's firm's fee. And on that, I'm just going to hit one other question that I saw in there. Somebody put, I think they were referring to the offer to purchase and the seller payment of buyer's firm's fee in there. I think the question was, okay, with this checkbox, why do we still need to have an offer of compensation with the cooperating firm? You might not need to. If you're working with a buyer who is your client and they would very much like to ask the seller to pay the buyer's firm's fee, you might not need to worry about a compensation agreement with the listing firm at all because the seller is going to pay you. So you wouldn't necessarily need both of those contracts. The offer to purchase is going to take care of that discussion for you. And reminder, like any provision in the offer to purchase, the seller payment of buyer's firm's fee, it's a provision that's negotiable between the parties. So if the buyer starts out asking the seller to pay the buyer's firm's fee and the seller's not keen on paying some or all of it, well, like any provision in a buyer's offer, the seller can use the counter offer to counter it out, propose something else. It's like anything else in the offer to purchase that it's negotiable between the parties.
And then, Jennifer, what if the buyer refuses to sign an agreement?
In the past, we have discussed this in the discussion of disclosure to customer form. You're required to ask them to sign the disclosure to customer form. Historically, we've said if they refuse to sign, what you're going to do is you're still going to provide them the disclosure to customer form, and you're going to document when you provided it to them and that they refuse to sign. I'm pausing a little bit here because I have a little bit of concern if the buyer refuses to sign this agreement, is it an agreement? And would it be compliant with the NAR proposed settlement terms? And I'm going to see if Corey has anything to add to that. I would be concerned about that as an agent going forward without a buyer's signature or something on there.
I would, yep, at least some sort of document that you attempted to provide it to them and they refused. Kind of like when someone doesn't want to sign the disclosure to customer form. I always tease, but it's true that sometimes you just have a separate document and you say, I presented this to you on this date and you are acknowledging that I did so. And would you please initial or sign here? And that seems to somehow get them to a comfort place. And that would arguably be meeting the objective.
Right. Because no one's saying that the buyer and the agent don't have an agreement about what their relationship is going to be. It's just you've got a buyer who's afraid to sign something because it looks like a contract, even though it very clearly says it's not.
And then I'm seeing a few suggestions that trying to utilize different types of platforms, showing type of platforms. Is there a way that we'd be able to facilitate that type of platform as a way to communicate offers of compensation? My understanding is at this time, and again, what I say today may be wrong in 15 minutes, depending on new interpretations, but my understanding is that that would not be a path because those are either realtor-owned, MLS participant owned, or MLS owned. And so in those circumstances, you would not be meeting the objective of the settlement agreement to be offering compensation through those types of platforms. But again, that is what we're understanding today, that those types of platforms, and there are a couple different ones in our state that I'm aware of, those would not be places that you'd be communicating offers of compensation. If you don't have a buyer agency signed, are you able to ask the seller to pay your fee? That one we're working through a couple of different conversations because in that circumstance, if you don't have buyer agency, you're technically either a sub-agent or agent of seller. And so you'd be receiving compensation from the seller or listing firm. And so that because you're an agent of that firm, just like you would through the facilitation of an MLS offer of compensation. So it would not be in the offer to purchase the way the pre-printed language is created right now. And Jennifer can disagree with me, but my understanding of interpreting is that the buyer may ask the seller to pay the buyer's firm under buyer agency, not under sub-agency. And so that is one of those things that I don't think buyers fully understand when you are working with them as a customer, that you're really not, that's the purpose of the form that you give them to disclose to them what you can and cannot, what duties you owe them and what you can and cannot say to them. I think it's important to re-emphasize that to them, which is why you don't see a disclosure to customer form having compensation in it. And ours will continue to not allow compensation to be included in it or afford a space for it.
So the question that I totally agree with that, like subagent, if they were recommending that the buyer include a provision asking the seller to pay the buyer's subagent's fee that they came up with, the subagent's putting their interests ahead of the sellers, which is a violation of license law. When you're acting as a subagent, you cannot put your interests ahead of the principal firm's client, which would be the seller. The question that came in that I lost there for a second was the agent said, hey, don't we have to charge every single buyer that comes through our firm the same commission amount? Here I am saying commissions are negotiable, commissions are negotiable. You charge whatever your firm tells you to charge. If the firm allows you as an individual agent to have a little bit of flexibility in what you charge agent or charge buyers, that can be a discussion with that buyer about the services offered and the fees that will be charged. And it doesn't, by law, it does not need to be the same for every buyer. However, you do not want to get yourself in a fair housing violation if you're charging based on protected classes. That would definitely be a violation of fair housing. But if it's a straight up negotiation between, equal parties in terms of what the service is offered and the fees charged, that is legally allowed. But again, you charge whatever your firm tells you to charge. If they give you the authority to negotiate that, no fair housing violation, and have a discussion with the buyer about the services that you're offering for the fees paid.
The question about, can you put a link in your MLS or an email address for the buyer's agent to go to so they can see the compensation is being paid by seller? My understanding is each MLS will set their own terms as to how you can facilitate the public remarks, the private remarks section. My understanding is that it will be unlikely that you'll be able to include a link to your page where you're indicating your offer of compensation. My understanding is MLSs are not necessarily going to want to adopt that because they're concerned that it may not meet the obligation under the settlement agreement. So again, I would defer to your local MLS and their policies relating to that. As only brokerage websites can offer compensation, again, per the settlement agreement, it says if it's my listing, I can offer compensation on my website for my listings. And so that's, again, very specific in the settlement about how you can offer that. Another conversation that was in the chat, are we required to have an agreement between the two firms in order to have compensation paid? I mean, if I want to enforce my contract against Jennifer and her firm because they offered to pay me X, I need to make sure I have something in writing to be able to enforce that. If I don't have that written agreement, I'm not super optimistic that I'll be able to claim my compensation.
I just want to say one other thing too about the offers of compensation, that a firm can definitely use their website to advertise what they plan to offer. And Corey mentioned before, an offer is not a contract. So even if a firm is offering me however much they're offering, I need to find out, what do I have to do to earn it? When is it going to be payable? I'm going to get a written agreement specifying the enforceability of that. However, firms can make offers of compensation on places other than their website. It could be on the yard sign. It could be in text communication with another agent. It's not only the website. The one thing we can't do, it can't be on the MLS, right? That's the one place that it cannot be, but we're not limited in terms of where it can be advertised per the terms of the settlement.
So Jennifer, I'm just going to read the question. If I do not have buyer agency agreement with a buyer, I am not able to ask seller compensation or ask seller to pay my commission and offer to purchase since I'm a subagent of seller. And that would mean I'm putting my needs ahead of the seller's.
Correct, which would be a violation of license law. So you can't use it that way.
Can firms not offer compensation and just allow buyers and sellers to negotiate through the offer?
Sure.
Yes.
Yeah.
And I see we're getting close to our 1 hour time frame. So in the event we're not able to get to your question, please make sure that you call the legal hotline. In addition, I would want to remind you that on our wra.org/antitrust resource page, we'll be having this presentation as well as the FAQs that we will be creating relating to practice changes. And then on that page, we'll also be referencing where you can go to learn more about form changes. We'll also be having articles, legal updates, those types of resource documents, and then also including more and more information about practice changes and the legal hot tips. And so again, we are trying to come at you in all different communication methods, as well as through different Zoom presentations to your firms or through these types of legal update lives.
I just want to say one more thing before we wrap up. I want to thank everyone that took the time to put questions in, or if you're going to submit them to us later. It really helps us to understand what the predominant questions are so that we can respond appropriately and get the information out to all of our members to make sure everybody's in a good position to practice once these practice changes go into effect.
So the last two things we will clarify and then we will wrap up. Are we considered subagents until we have buyer agency signed? If so, why is a touring form needed? Again, if you want to participate in pre-agency where you're not representing or working with a buyer technically as a client or customer, that is what the pre-agency form is for. If you don't want to use that, you skip right over it and you can go to buyer agency or to a customer. And so again, we'll be communicating more and more about you or to you in a little while. I think the last thing, Jennifer, before we close, I would just ask you one more time to reaffirm about the CE credit. So for those that haven't received course 6 yet, they can understand what the next steps are.
Yes, if you have not completed course 6, and just for those of you who are with us in March at our Legal Update Live, we did offer credit for that Legal Update Live for course 6, so that if you got credit at that Legal Update Live, you're already done with course 6, so you would not be able to get credit for this version of course 6. But if you've not completed it yet, look for the link, or if you've got agents who are going to take this later, they'll be able to access the quiz after they watch the recorded presentation. 5 questions. In and out, get yourself 1 hour of CE credit on Start Your Monday Off Right.
And thank you everybody for attending today. We know you have lots of questions. And so again, if you have questions about the CE credit, or if you've just received your license, please feel free to reach out to the legal hotline or to the education department. We are grateful for your time today. We're appreciative of your being a Realtor member. And as always, we are here for you and we hope to be able to provide you the resources and tools you need.
Buying a home by yourself can be a lot. Buying a home with a realtor isn't. Paperwork, inspections, appraisals, deadlines, showings, market research. What you reading? Viewings, understanding legal documents, negotiating offers, coordinating inspections, securing financing, handling close. Well, you get the idea. A realtor can expertly handle the details, so you don't have to.